Bill Chatt with Joshua Rosenzweig with the Cervantes Chatt and Prince Legal Minute. Today we're discussing estate planning. Estate planning is something that Josh and I both do. We're also real estate attorneys. Those typically go hand in hand, particularly when we're dealing with real estate in the estate planning process. So it's a big field of topics. We're gonna start actually with something before we get to the estate planning and the documents and all that. We're gonna start with something that's kind of relative to both of us as we're a little bit older, and that means our parents are a little bit older. So as much as we get questions about people wanting to set up estate plans, a lot of times we get questions about people and their parents. So let's start there. The call we get a lot is a parent has passed away. And so this is a two-part process. It could be one of two parents has passed and one remains alive, or the sole parent has passed. So typically the first thing you ask the person on the phone is, did they have an estate plan, right?
Mm-hmm. Absolutely.
Did mom and dad ever talk to you and say, hey, I've got an estate plan and here it is? So that's kind of the first question that I ask. How about you?
Similar. I will make sure that there is an estate plan when I start. And the reason that we do that is because that's going to govern how we operate. Whether there was a will, whether there was also a trust is also going to significantly impact how we proceed. Typically what I try and do is get my hands on that will or trust as soon as possible. A good reminder is that state law indicates that a will has to be filed within 30 days of the person's passing.
And 99% of the people don't know that.
And while the statute says it's a felony, I've rarely ever heard it ever be enforced.
Right.
But we want to get our hands on the will because then we have an idea of who the executor is, an executor being the person who is in charge of administering a deceased person's estate. And once we have our hands on the will, the next step, at least in my process, is to make sure what assets do we have?
Right.
What are we dealing with? Because Bill mentioned early on in this discussion, whether it's the first parent to pass or the second parent to pass, in most instances, what we find is that married couples have jointly owned assets, which then for those specific assets means the will doesn't matter because the surviving spouse takes. However, what happens with those assets that don't have a joint account holder or a beneficiary designation? Those are the assets that we have to pay particular attention to with respect to the will.
Right. And so to just dovetail onto that one, in the event that everything's held jointly, whether it's the house, maybe it's the bank accounts, there may be nothing to do when one parent passes. Let's go to the instance where we're down to the sole parent, and let's put scenario one into place. There's no estate plan. Let's start with the easiest. Mom was living in an apartment. Mom was getting Social Security and had $4,000 in the bank. Not a lot of assets to deal with. What do we do in that one?
Well, state law, again, says that we can use a small estate affidavit to administer that estate. And for those listening and seeing this who have heard of a small estate affidavit, it applies when a decedent passes without ownership of any real estate and less than $100,000 in personal assets. So cash, jewelry, cars, things of that nature. The statute says, the Probate Act says, that you can use a small estate affidavit and avoid having to go to court to administer those persons' assets. But again, as Bill and I have experienced, that seemingly easy solution is rarely put into effect.
And why is that?
Because banks, even though they're allowed to accept, and other financial institutions, even though they're allowed to accept a small estate affidavit to distribute an asset held by a decedent, oftentimes they're requiring that we do a full-blown probate estate.
And I'll put it in the context that I put yesterday. You're going to be dealing with some 22-year-old kid at the counter who is just told what to do.
And has a checklist of what they're supposed to take in.
Right. And you can go ahead and argue with that kid and say, you're supposed to take it, but he ain't going to take it. He ain't going to set up that account. And you've got a check made out to an estate that's not been set up.
I have actual experience with this. I had a check drafted to the estate of a deceased person for $2,400. Even banks that I have a long-time relationship with, who I've represented in trust matters, contested estate matters, would not touch that check without me having gone through the probate process. So we had to open up an estate in that situation. If there's a car, actually on the Secretary of State's website, there is the form affidavit, small estate affidavit, which the Secretary of State's office will accept to transfer a vehicle title.
Right.
But if you find that you're dealing with a bank account or a check, you are likely going to have to open up a probate estate, and that small estate affidavit isn't going to help us out.
Right. I've heard, we as attorneys have to do a lot of continuing education. I actually just did one yesterday. It was on changes to the Power of Attorney Act, which we will discuss in future episodes. And we were talking towards the end about the small estate affidavit. And there's some language in the small estate affidavit portion of the probate code that says that if the affiant is the one presenting the check, the financial institution may accept it. So now we've got some express language. Again, if they don't do it, they don't do it. And you're going to hear them say we need letters of office, and that means opening an estate. So that's kind of where you are when there is no estate plan and a small estate. Right. Now, and it does happen, if we're down to one parent and we do have real estate, and let's say there are things like bank accounts with $125,000. We've got real estate. We're out of the box on small estate affidavits. What do we have to do?
So you're going to start with filing a petition to open a probate estate in the county in which the decedent passed. So if they lived in Burr Ridge and it was the Cook County side of Burr Ridge, you're filing a probate petition in Cook County Circuit Court. If it's on the DuPage side, you're filing it in DuPage County. That's the first step, is you have to be in the county in which the person passed. Opening up in a probate estate, there's forms for virtually every county that we go into. So the forms are not too difficult. The problem or the difficulty can be finding the right person to act as in this instance, without an estate plan, it would be an administrator. Typically what you find is a child or maybe a sibling of the decedent. Sometimes a child or sibling aren't close by. Maybe there's a close friend who usually will pick up the torch, so to speak, and carry on the process.
Right.
Once you file the documents, so typically the courts are requiring a petition, an affidavit of heirship, because the court and the Probate Act require that we know who the heirs are. Those are the people that have a blood relation to the decedent. And then an oath and bond. The court wants to make sure that the person who's filing the petition is going to do right by the estate and not steal anything.
Nothing personal, it's just the law.
Exactly. And so once we get those filed, again, depending on what county we're in, we're going to be in court a few weeks after those are filed, where hopefully we have all our documents in order, and the court is going to enter an order opening the estate and appointing our client as the administrator of the estate.
And maybe just to kind of wrap this up on this topic, just about mom and dad, there's one class of assets which may not be subject to either the trust or the will, which will be financial accounts if mom or dad have completed beneficiary forms.
Right.
So things like IRAs, CDs, things like that. Most of your financial institutions, when they set those accounts up, they will literally say, here's a beneficiary form, fill that out. And if those are complete, then what's the result?
Then we don't have to worry about taking that specific asset to probate.
Right.
One thing I want to be clear about is when we say probate, it can be used in a variety of different contexts. For this discussion, when we say probate, we're talking about a court proceeding where we have a judge overseeing the administration of somebody who's passed away's assets and their liabilities as well. It bears worth repeating, though, we have to make sure who owns the assets and how they're titled, and as Bill just mentioned, the beneficiary designations. Anything that has a beneficiary designation, anything that has a joint account holder is not a probate asset and therefore does not need to go through court. Usually you would just have to file a claim form as the survivor and the survivor beneficiary in order to get those funds or get that asset.
And it's true of a number of different categories. You know, like I mentioned, financial accounts, pensions, IRAs, things like that. So there could be anything. So that's something we're gonna. That's what we like to call a belt and suspender step that we're gonna take and say, hey, you know, now maybe that they didn't complete it or there's something unclear. If that's the case, it will fall into our probate estate.
Absolutely.
Okay. All right. Well, I think that's it for today. We've got lots to come on this topic. So any questions or anything like that, you know where to get us, ccpchicago.com. And thanks for your time.
Thank you.